Good evening, everybody. It's good evening from Oxford, where the whole map team is assembled in the map room for our Tosca seminar this evening. I'm Liz Baigent. I'm one of the conveners of Tosca, and Nick Billy will be chairing questions at the question and answer session at the end as the other convener. Please put your questions for our speaker in the Q&A box, which you'll find at the bottom of your screen. Don't use the chat box because we might not pick that up. Use the Q&A facility there, and Nick will be chairing those questions at the end. So before I introduce our speaker for this evening, just a few announcements from the cartographic world. First of all, the Maps and Society lecture series has an in-person seminar coming up this month, and exceptionally, that seminar will be in Senate House, University of London, not the Warburg, as normal. In fact, there are two, I see, on the 16th of this month. Isabella Alexander, who we'll be meeting very shortly, will be speaking on maps, makers and markets in the early 19th century, a view from the legal archive. And she'll be talking about substantially different material from what we'll be discussing tonight. So please do go along and hear Isabella again in London, if that's a possibility for you. And then on the 7th of December, also in Senate House, Maps and Society are fielding Tom Simpson from the University of Warwick, talking on the subject Maps That Made Climate Change, 1800 to the present day. And our sister series in Cambridge Seminar on the History of Cartography, will be holding a seminar later this month via Zoom, and that's going to be on the 21st of November, when John Montague from the American University of Sharjah, I hope I pronounced that correctly, who's an associate professor of architecture, will be speaking on the subject Lines Endowed with Lawful Force, the maps and drawings of the Wide Streets Commissioners of Dublin, 1758 to 1849. Now, to return to Tosca, we have another event this term. On the 30th of this month, we have a field trip, which is an in-person event, Mapping Middle-earth, How Tolkien Created a Convincing World. And that's going to be taken by Catherine McElwain from the Bodleian, who is the Tolkien curator of manuscripts. Now, there are just 7 places left for that field trip, so if you'd like to go, please let Nick Milley know as soon as possible. I'm sure you all know his email, but it'll be it was rotating at the beginning, and he'll remind you at the end. So on to tonight's events. Tonight we're continuing our map readings series, in which we aim to show Tosca audiences some of the latest literature in the history of cartography, to tease out in conversation with the authors the arguments of the books and their implications and where they've led their authors. And so far we've considered Matthew Edney with his 2019 book Cartography, The Ideal and Its History. We've turned our attention then to time in maps, and most recently Encounters in the New World on Jesuit cartography with Mirela Altich. And tonight we're considering this excellent volume. I'll just hold it up for you. Copyright and Cartography, History, Law and the Circulation of Geographical Knowledge, published just this year. And it's a pleasure tonight to have with us the book's author, Isabella Alexander. So welcome, Isabella, to Tosca. And we'll see you on screen shortly. And rather than my introducing you, I wonder if you could, for our audience, introduce yourselves and tell us something of your intellectual background, your present position, and as a little introduction to our talk tonight.
Thank you so much, Liz, and thank you, Liz and Nick, for inviting me to give this talk about my book, which is really exciting to be here talking to all of you about it tonight, because this is my other map. Historians is my other audience, and I've spoken a little bit so far to lawyers, but it's exciting to speak to map people. So I am a professor in the law faculty at the University of Technology, Sydney. So I teach and research in intellectual property law. And my main research interest has always been the history of copyright law, although I've done a few other things along the way. So yes, and that's my kind of intellectual background, I guess.
Excellent, thank you. I think you're probably the first lawyer to speak at a Tosca seminar, so it's excellent to have your perspective. And I wonder if you could tell us how you became interested in maps and map history in general.
Yes, so I didn't really intend to spend quite this long working on map history. Probably about, I think maybe around 2010. I'd recently finished writing my first book, which was based on my PhD, and I had done that at the University of Cambridge, and I was working at the University of Cambridge, and my first book was on the history of copyright and the public interest in 19th century Britain. So I'd mainly been looking at books, copyright in books. And I believe it was Lawrence Worms came to Cambridge to give a talk about the map trade in the 18th century at Emmanuel College, and someone sent me the notice of the seminar saying, this looks interesting. And I thought, yes, that would be really interesting. But I couldn't actually go to the seminar. Unfortunately, I had something else on. But I thought, oh, that would be an interesting kind of offshoot of my work on 18th and 19th century copyright in books. No one has really looked at maps. So I thought maybe that would be interesting to write an article on that. And 12 years later, I finally finished the book. So that's where it started. And just the more that I looked into it, the more I realized that there was much more than an article here, that no one had done any of this work, and it was just so much more interesting. And there were so many more dimensions to it than I had originally envisaged. So
maps do have that capacity to suck one in, don't they? So, that's very interesting that it was our sister series over in Cambridge that sparked your interest. I'm sure Sarah Bendel, who convenes that series, will be pleased to hear that. So on to the book itself, which I can thoroughly recommend. And as I was reading it, it seemed to me, in a sense, the question of what is a map, which historians of cartography are very used to seeing posed and answered in a number of different ways. It seemed to me, in a sense, that was at the heart of your book. And of course, lawyers come up with very different answers to that questions from historians. I wonder if you'd agree that the question of the nature of maps is at the heart of the book, and how much it shaped the story of your book and contributes to broader questions of what is a map.
Yes, I think I've got a slide to go with this, so I might just start sharing my screen, if that's okay. It's a kind of, I guess, a visual display of my interests really on this slide. But I think that the question of what is a map is in a lot of ways the question at the heart of the book, but I think I probably ask it in a few different ways, and I also offer probably a few different answers. So perhaps one way that I asked the question was, how is the map understood? And then explored how that question was answered by the law, or how it was constructed by those who were bringing maps to law. So in a number of the legal cases that I look at, you can see the plaintiffs and the defendants, through their lawyers, explaining to the court what they think is important about a map through their complaints about copying, what was copied, their reasons why they thought there was no copying, or that there was copying, but it was not wrongful in a copyright sense. So I was also very influenced towards the end of my work by Matthew Edney's book, Cartography, The Ideal and Its History, which you've discussed in an earlier episode of this series. And so I became interested in thinking about the way that the law was another element that worked to create this ideal of cartography, because increasingly you see judges as well as litigants buying into this notion of a map as a simple mirror of nature. So, for example, in a case of 1806, the Lord Chancellor asked It might be asked how it's possible to have a copyright in a map of the island of St. Domingo. Must not the mountains have the same position, the rivers have the same course? Must not the points of land, the coasts connecting them, the names given by the inhabitants, everything constituting the map be the same? And interestingly, of course, in 1806, those points were nowhere near as definitively fixed as they are today. So the statement was projecting onto maps an accuracy that was simply false, not to mention assumptions about the names of places and whether or not they're given by the inhabitants. But in any event, the Lord Chancellor located the copyright as subsisting not in what the map depicted, but in the labour expended in the map's creation.
Right, that's really interesting. Thank you. Maybe sort of following on from that, just so we can root our discussions a bit more, could I just ask you, just for our audience, to sketch out the story you're telling in the book, and then we'll get into a bit more detail about some of it.
Yes, so I've got a slide for that as well, if it would but come up. Come on, slide. Okay, there we go. So the story that the book is telling is really to trace over time map makers' encounters with the law, mainly through using the legal record. So the story that I tell really starts with around the invention of the printing press, around 1440, and the rise of map printing in the early modern period, and the use by those early map makers of different legal instruments to try to make their operations commercially viable. So then I turn to the 18th century, and I look at the passing of the first copyright legislation that protected maps as prints produced through the process of engraving. Then I kind of turn to the follow some of the earliest litigation that flowed on from those statutes and how they interpreted them. Then the book moves to the 19th century. So I've got a chapter on the rise of the Ordnance Survey and another chapter on the UK Hydrographic Office and how both of those institutions thought about copyright law. And then I turned back again to look at the private map trade, to look at how the changing social and economic conditions impacted their relationship with copyright law, as well as the influence of this kind of growing availability of state-produced geographic and hydrographic data. And then finally, the book looks at the legislative enactment of Crown copyright and uncovers the role played by the Ordnance Survey in this new statutory concept, which is a concept that is quite contentious into the present day. Oh, I think you've gone on mute again, sorry.
Thank you. So as you say, you go back as early as the 1400s, but it's mainly a story of the 18th and 19th century. So I wondered if you could elaborate a bit more about what your findings from those two centuries.
Yes, so in that chapter 2, I try to cover a period of about 200 years. So it obviously is a little superficial in some respects. But the story I'm telling or trying to tell is that as maps start to proliferate in Western Europe, map makers begin to explore different ways to make these enormously expensive and labor-intensive endeavors commercially viable. I mean, I don't think anyone expected ever to get rich making maps, but they needed all the help they could get just to stay afloat. So one popular strategy was to request a privilege from the ruler, usually the king, and that privilege would normally give the receiver the right to print the work, or sometimes groups of work in question. So that would usually mean that the person who received the privilege was the only person who could print and sell copies of the work. They would generally last for a specified term of years. And sometimes they would also set up penalties for anyone who acted in contravention of the privilege. So I look briefly at some of the privileges that were granted for maps in Europe before turning to spend a little bit more time on England. So I've got a slide for that. So in England, the privilege system was supplemented by a second system. So this was trade regulation through the Stationers' Company. So anyone seeking to print or publish books in England and Wales and later Scotland had to be a member of the Stationers' Company and registered the books that they printed at Stationers' Hall. So some map makers were members of the company and used the register. Others would find a member and get them to register the work. So I look a little bit at that, and there's also this. I've got a picture on the slide of what's probably the first privilege to be granted to a map maker, and that was the one that was granted by Queen Elizabeth I to Christopher Saxton in 1577. So I looked a little bit at that because I was able to find the privilege and see more or less what it says. It's quite hard to read. So then I turned to look again in a little bit more detail at the map making operations of two well-known 17th century map makers, Richard Bloom and John Ogilvie. And what I'm interested in there is to kind of examine the range of strategies that they used to bring their maps, well, particularly focusing on, they both had publications called Britannia, so to how they brought those to market. So here's my images for John Ogilvie. So what I'm interested here in is what role the privileges were performing as compared to or alongside registration at Stationers' Hall. So why did mapmakers ask for them? What work were they doing? And the conclusion is essentially that privileges and registration were two of a range of strategies that mapmakers employed to get their enterprises off the ground. And also to kind of create some kind of official imprimatur, if you can say, that was placed on your map, again, to add value. So because maps were so expensive to create, and Ogilvie, of course, went even further than Bloom because he actually sent out surveyors to measure the roads, further increasing the costs involved. So I think Bloom and Ogilvie used pretty much every lever that they had. So raising money by subscriptions, holding lotteries, patronage, various forms, favours from the king, such as dispensations on customs duty, royal orders encouraging people to buy the books when they were produced. So Bloom was a stationer, so he could register at Stationers' Hall, but he also sought privileges from Charles, and Ogilvie also sought and received royal privileges. So the argument is that the privileges might not necessarily have stopped others from copying either the maps or the information in them, but they did probably give market signals, which might have discouraged some copying, as well as confirming a kind of royal aura or imprimatur of authority on the works in question that also had a market value.
Thank you. So this is a story exclusively about printed maps.
Yes, it is, because it's a story about reproductive technologies and the law. So it's about how legal attempts to regulate reproductive technologies played out in relation to maps. And it's also a story of maps as commodities, which printed kind of reproducible maps were in a way that is different to the kind of commodity that a manuscript map is. So a manuscript map, I would argue, is a very different artifact, both as a material object and as a legal object. As a material object, its value lies in its singularity, as well as perhaps the purpose for which it was made. As a legal object, simply what a lawyer would call a chattel, a piece of movable personal property. But once printing comes into the picture, you introduce a second layer of value. So now the map has value not only as a physical object, but also there's a value in being able to make and sell copies of that object. So copyright creates rights in respect of that value, but those rights are intangible, which means they can be held separately to the physical item. So it's the interaction between those two sets of rights, as well as the operation of the intangible copyright, that interests me.
I see. Yeah, that's really interesting. I don't know if you know Anne Blair's book, Too Much to Know, when she talks about managing scholarly information before the modern age. And her argument is that sort of compiling, copying, reworking, didn't have the sort of overtones of being morally dubious, sort of commercial hack operations that they have today. But they were part of an attempt to make sure that knowledge wasn't lost again, as it had been in what used to be referred to quaintly as the Dark Ages, so that the idea of intellectual property and plagiarism didn't really work in the context where people were trying to stave off the wreck of knowledge. So a part of a sort of scholarly, it was a sort of joint scholarly, seen as a joint scholarly enterprise rather than infringement of rights. I wonder how her argument works, meshes or doesn't with yours.
Yes, I think probably that this is one of the tensions, I guess, at the heart of a lot of debates in intellectual property law, not just copyright, but also patents, this kind of tension between generating more knowledge and claiming rights over it, so that knowledge can be commercialized or further encouraged. So how do you encourage people to produce this knowledge? It is by restricting the sharing of it. But I also find it interesting to trace the rise of this argument that copying and compiling and adapting are bad and morally wrong. So I think at the start of my period, so the end of the 15th century, and over the next 100 years or so, protection against copying is pretty limited. But it is, I mean, you can see it's a concern because people are asking for privileges that prevent it. But the kind of protection you get is very limited, and it usually relates to the specific work in question, so an identical copy. So it's recognized very early that this protection is needed to protect the kind of the market of what we would today call the first mover, because it's so much cheaper to make a copy. But of course, in those early days, there were also a lot of expenses for copiers. So you still had to engrave the plates. You had to pay for the copper and the paper and the labor. So there were a lot of non-legal barriers also in place to copying. So making a copy that was a substitute and could undercut the market of the original was a marketplace harm. But those affected by it were also not averse to placing it in a moral context. And that's where you see the rise of kind of using metaphors such as literary theft, piracy. They're accusations that carry moral condemnation as well as legal condemnation. And in my discussions of this early period, I've paid attention to the work of people like Mary Pedley and Yolande Hodson and Lawrence Worms, who pointed to the extent of copying in the map trade. So essentially, you couldn't make maps without copying. So yes, copying was, essential. And I think Lawrence, in particular, argues that shifts over the course of the 18th century, giving rise to a new generation of map makers who prize accuracy and new data over outdated data and copying. And I argue that copyright plays a role in that, because with copyright, you're better able to protect that investment of labour, and it signals that the days of copying are over. I think at the same time, it was recognised much more explicitly in earlier periods that granting these rights would but also drive up the cost of scholarly useful works, making them unavailable to people with lower kind of resources at their disposal. So the earlier privileges and legislation was much more permissive in terms of the kinds of copying that was allowed, which also recognised what was happening in practice, that books were being extracted in journals and magazines, that maps were being copied with updated information and made available to different audiences with beneficial impacts on education and learning more broadly. So yeah, that's my answer to that.
Yeah, that's interesting. Thank you. Maybe we should turn now to your central period, the 18th, 19th century. And I wondered if you could just outline for us some of the significant cases that you encounter and their significance in the period.
Yes, so I guess the set of cases that most kind of usefully illustrates the point I've just been making are the cases involving sea charts and the chart maker John Hamilton Moore, which are some of my favourites. So these were 3 legal actions that were brought against Moore at the end of the 18th century. And in these cases, you can see the courts clearly prioritising public interest concerns over the claims of private property owners. And I really like these cases because they give such a great insight into the relationships between map and chart makers in the late 18th century as being also quite legally significant in terms of developing copyright law. So John Hamilton Moore was quite a colourful figure. He seemed to inspire a lot of strong loyalty as well as kind of enmity. He taught navigation, he sold nautical instruments, he wrote sailing treatises, and he soon started selling hydrographic charts. So the first case that was brought against him was brought by the leading print seller Robert Sayer in 1785. So Sayer had purchased Thomas Jeffrey's stock, and he accused Moore of copying one of Jeffrey's American charts. Sayer brought the case in the Court of King's Bench and claimed an enormous £10,000 in damages. But Moore was able to win the case against him by putting on the stand various of his nautical contacts who testified that Moore hadn't been simply copying, but he had significantly improved the Jeffreys charts with more accurate information. So then the next case brought against Moore by another rival chart maker, David Steele, and again Moore succeeded by bringing witnesses to give evidence that his charts were superior. But the third case was brought, I've got a slide for that as well, by Moore's former shopman, Heather, and Heather had learnt more than just how to run a chart business from Moore. This time Heather produced witnesses showing that his chart was superior to Moore's, and so Moore lost the case. So the first of those cases, Sayer and Moore, was the one that was significant in terms of legal doctrine, because it was heard by Lord Mansfield, who was the leading commercial judge of his day, and he made a pronouncement to the jury about copyright, which went on to be quite influential in later copyright cases, not just involving maps and charts. So I'll put the quote on the slide. It's quite famous. So Lord Mansfield said, "In deciding, we must take care to guard against two extremes equally prejudicial. The one, that men of ability who've employed their time for the service of the community may not be deprived of their just merits and the reward of their ingenuity and labour. The other, that the world may not be deprived of improvements, nor the progress of the arts be retarded." So this has been a really influential statement over the centuries because it so neatly sums up the tension at the heart of copyright law. But it's also interesting because it falls much more generously on the side of improving the circulation of knowledge than the law does today. So that's an example of some of the cases I look at in the 18th century. In the 19th century, I might point to the case of Atlas and Fullerton, the Atlas Company and Fullerton, as being quite significant, partly because it was fully argued in the Court of Session in Scotland, and quite a detailed report was printed of the proceedings. So often in these cases, the legal record doesn't tell you that much, so it's really helpful to have. So we've got an example on the slide of the summons, but you have to piece it together from a lot of different areas. It's not as legally significant in the terms of laying down precedent, but I think it is significant for a couple of other reasons. So first, it involved the highly respected map-making firm of W&A.K. Johnston, and it was brought against them by another established Scottish family firm, Archibald Fullerton and Company. So these were significant players in the map-making business, and it mattered to them and to their ongoing business how the case would play out. It's also great because we have reports of what the witnesses said in evidence, as well as what the lawyers argued at length. So we can get a really immediate sense of how factors like authorship, authority, and reputation interplay and interact with other questions about the work that maps are doing in the world in terms of the purposes that they're used for as physical objects, but also as carriers of important information. So in this case, the atlas in question was the Grand Oeuvre of Alexander Keith Johnston. And he took the stand to emphasize the enormous amount of labor he'd expended over many years. So although he hadn't carried out any actual surveys, he emphasized the scientific nature of his investigations. He explained his process for ensuring accuracy and authority, which included working with a number of other well-credentialed collaborators and colleagues. So the version of authorship put forward by the Johnston team was collaborative rather than individual, but very much based in scientific method and community. Fullerton, by contrast, in defense, put up some witnesses who disputed that copyright could even subsist in a map, notwithstanding over a century of legislation and litigation to the contrary. But less dramatically, they also put forward the argument that they are entitled to take any information they wanted from existing maps, which was exactly what Keith Johnston had done. So the pursuants, the Johnstons, countered this argument by focusing on the technology of copying that Fullerton had used, which was a pantograph. So notwithstanding it was commonly used in map making, in the court it was characterized as a cheat, a way of making a slavish copy, one that added no value. So you can compare that to the Moore cases I mentioned earlier, where value was being added in the copying. If you used a pantograph, you weren't adding any value. And Johnston's counsel decided it as unfair, dishonest, and even contemptible. So this case was one like the Moore cases almost a century earlier, on the basis of being the right kind of author and the wrong kind of copier.
Thank you. That's really interesting. To see the way that that's moving. And did you sense in these cases that the lawyers had any particular interest in maps, or were they just taking on these cases for bread and butter reasons?
You never really sense that. It's really hard to tell what their interests are. The one I liked, I mean, the only one I could assume maybe brought a bit of extra knowledge to the case was in the last Moore case that I referred to. Heather's counsel was Thomas Erskine, who was quite a noted orator of the day, but he had also been a midshipman in his youth. So I thought I speculated that he perhaps had a particular interest from experience that sea charts should be more accurate. But aside from that, yeah, I really don't know.
No glimmer of interest there. So things obviously change when the state has a direct influence over the control of maps, the production of maps, and the control of information going in through them. That is, once the Ordnance Survey and Hydrographic Office come into the picture. So how does this affect matters, I wonder?
So yeah, this is obviously a huge change in terms of geospatial and hydrographic data, because now we have the force of the state behind them. I was going to say the full force, but it was never really the full force. Often the state support seemed rather grudging and shoestring-like, but it certainly far exceeded what private enterprise could ever dream of investing in terms of gathering, generating, and producing geographic information. And what's interesting is that these two bodies do have a really different relationship to copyright law, because they were state bodies, so charged with creating maps or charts for public purposes. When it came to copyright law, it wasn't so much a tension between private rights and public interests as a question of how, or indeed whether, copyright could be leveraged in pursuance of the public interest, and what was the best way of doing that. So it also highlights the different public interests. Was it the questions that these bodies are grappling with is, was it best to use copyright as an economic tool, so to make more money from maps and charts that could then be ploughed back into improving kind of underwriting the enormous costs involved? Was it better that maps and charts were more widely available? So the data in them, should it be freely available? What should the cost point of sales be? Could you control the maps and the charts, but not the information or data they contained? Could copyright be used to bolster the authority and reputation of the maps or charts? Because it's obviously crucial to them, to their effectiveness, is that they're authoritative and recognized as being authoritative. So it's also really interesting to compare the two. The Ordnance Survey emerges at the end of the 18th century. At first, it's only doing surveys, and when it decides to make maps, it's first forced to turn to the private trade for their publication. So the first county maps were published by the leading London map seller, William Fadham. And at the same time, the directors of the Ordnance Survey were making their survey data available in the philosophical transactions, and they were very happy for it to be used by others. This then starts to shift in the period of 1811 to 1816, when the maps were withdrawn from public sale, probably for security reasons. And when the decision was reversed and the maps went back on sale, Mudge, who was the director at the time, began to complain about the London map sellers using OS data to publish their maps at reduced scales, which he thought was likely to reduce the sales of his maps now that he was able to put them back on the market. So legal advice was sought and given to the effect that any map seller using the data would be in breach of copyright law. I think one could query whether that was in fact correct at the time. But in any event, Mudge talked the Board of Ordnance out of instituting proceedings. He thought it would be better to stay on good terms with the private trade. because they still needed them, as they do throughout the century, but there's always this continuing tension. So on the one hand, even when the Ordnance Survey is printing and publishing its own maps, it still needs the distribution networks of the private trade. And it experiments with a range of different agency arrangements to try to broker that relationship. On the other hand, the survey is very expensive, and the government always wants to cut costs. So selling maps seems like a way that the OS could start to pay its own way. And periodically Treasury insists on this. But the successive Ordnance Survey directors understand that there are really two key factors militating against that. And the first is their strong sense of a public duty. The maps are being made with public money and so should be accessible to the public. And the second is that there's a range of markets for maps, and they all need slightly different maps on different scales, showing different areas, displaying different information. And the Ordnance Survey simply can't service all of those markets and needs. So the most efficient and effective way of getting this data out is to let the private trade service some of those markets. But of course, it's really difficult to draw the line between what the trade can do and where their activities start to cannibalize a market that the Ordnance Survey wants. So copyright is repeatedly drawn upon to try to assist in drawing that line. As time goes on over the century, I think the survey inches closer to litigation against private map sellers overstepping that mark. They have regular run-ins with Bartholomew's. Put a little slide on my slide. Particularly because Bartholomew's uses map titles such as Reduced Ordnance Survey. They want to show where their data comes from, but the Ordnance Survey suspects that it's drawing away consumers and complains that it's misleading. People will think that these maps are official Ordnance Survey maps. But despite this there's a lot of correspondence, but no actual proceedings until after the 1911 Copyright Act introduces a specific provision stating that that anything that's any work generated by a government department or an employee of that department will be Crown copyright. And the Ordnance Survey was heavily involved in getting that clause inserted into the legislation. And that meant that by 1913, they then felt secure enough to launch their first copyright proceedings. But they don't choose a big firm like Bartholomew's. They choose a fairly small-time operator, Ernest Augustus Much, who was issuing maps for cyclists. So this is the map on the slide is the one that's in the file of the litigation. And the case was actually brought as a criminal prosecution, and Much was fined £40 plus 15 shillings in costs. So that was what the Ordnance Survey was doing with copyright. And it's interesting to compare and contrast that with the UK Hydrographic Office. So it was established around the same time at the end of the 18th century. Likewise, well, at first it didn't make its own charts. It simply gathered them from the private trade or bought them from ship's captains. So at the early stage, copyright was seen as an impediment to the Hydrographic Office's mission of supplying accurate charts to Her Majesty's Navy, because it was held either by the individual captains or by the private chart sellers. By the end of the 19th century, the Hydrographic Office had decided that the best way to produce or to get charts to the Navy would be to make more of its own surveys. Sorry, by the start of the 19th century, not by the end. And also to sell those results to the public. So by providing much more accurate charts to the public trade for sale, that would help improve the availability of accurate hydrographic data, which would then hopefully in turn reduce shipwrecks and loss of life. And that would be beneficial to the trade interests of Great Britain as well as her defence interests. But this approach opened up much the same problem as we saw for the Ordnance Survey, namely that the private trade would simply copy the Hydrographic Office's data into their own charts and sell them in preference to the Hydrographic Offices. And a second problem, which was more pressing for the Hydrographic Office than for the Ordnance Survey, was the matter of inaccurate charts, which could be and frequently were the cause of maritime disaster. So the Hydrographic Officers not only had to be the most accurate, they had to be known as being the most accurate. And if their data goes into private maps, they can't, or charts, they lose control there. So again, they tried different strategies to manage the situation. And the chief approach was to appoint official agents for the sale of charts, but there were frequently problems with that. So the agents were given discounts, but they're generally not large enough to induce them to sell hydrographic office charts at the expense of their own. Another similarity with the Ordnance Survey was the existence of different markets, which were served by different kinds of charts. Although in the case of sea charts, there were really only two main types of customer. So the Navy and the Merchant Marine. The Merchant Marine preferred a different type of map known as a blueback. So these maps tended to be on a smaller scale and covering large areas, with inset plans for ports and narrow passages, whereas Navy charts needed to be on a larger scale and able to give more detail of unfamiliar coastlines. They also were less decorative in appearance, which potentially made them less kind of commercial. And the difference between the two meant that the private blueback chart makers often just needed the Admiralty data rather than a complete copy. Generally, the Hydrographic Office was happy with that, but from time to time, concerns were raised about using its data in charts it had no control over due to that potential for reputation damage. The other similarity between the Hydrographic Office and the Ordnance Survey was that the Hydrographic Office was likewise under pressure from the Treasury to reduce its costs, and maybe to use copyright law, the monopoly that it had over, or to enforce a monopoly over its charts. But the Hydrographic Office, the hydrographers, consistently resisted using copyright law against private chart makers who copied its data. And they thought that allowing its superior data to be freely available was the best way of reducing loss of life at sea. So it continued to focus more on its relationship with the private trade, seeking to capture some of the market for nautical information, but didn't really want to take on the burden of supplying the entirety of British shipping. So I guess to sum up, looking at these two organisations gives us a new perspective on how state making operates. That's with the focus on copyright. It's much more granular, and I think it complicates broader conclusions that people frequently make about the relationship between state mapping and empire, and the nation state, and so on. For copyright lawyers, the point I think is interesting about looking at these is that copyright doesn't have to be litigated or enforced to be an organizing principle for the way a business might operate. It does useful work at a more local level, negotiating the boundary between private rights and public interests.
Thank you. That's such an interesting perspective. As you say, it's sort of one that's very fresh to the study of the history of cartography. Another new perspective that I was fascinated with in the book was the division that you identify between the literary and the artistic. And that's not a distinction that most historians of cartography were really have thought about with respect to maps. So we're used to thinking about other dividing lines, say between an artistic map and a scientific map and so on. Can you elaborate, I wonder, on how that distinction between the literary and the artistic affects the law on map copyright?
Yeah, it is really interesting to compare those dichotomies. So, I mean, you say that map makers or cartographers think about artistic versus scientific, and for intellectual property lawyers, that would mark the distinction between copyright law and patent law. So patents is about science, right? It's about art or literature. And as I mentioned earlier, so patents were a form of privilege that were the earliest way of controlling the production and copying of maps. But as patent law began to focus more on scientific inventions, more emphasis began to be placed on the map as a material object and a commodity rather than a technology, I guess. And you could argue that that's when they kind of fall into copyright law and out of patent law. But then you come up against the literary and artistic dichotomy. Because in the early days of copyright, it wasn't seen as self-evident that a book would be treated in the same way as an artwork when it comes to copying. So different regimes emerged for different cultural products. There was a regime for books, there was a regime for engraved prints. Not until late in the 19th century is there a regime for paintings and drawings. And by that stage, 1862 Fine Arts Act, copyright had moved into the regime for protecting books. So it was included in the Literary Copyright Act of 1842. But because the Engravings Acts that I referred to at the start hadn't been repealed and still applied to engravings, maps could be protected under both regimes. So they could be protected as an engraving. They could also be protected within a literary copyright. Arguably, they could also have been protected under the Fine Arts Copyright Act, which is really interesting. It doesn't come up at all in my book, and it was only recently pointed out to me. And I do think that the reason nobody ever suggests that maps should be protected as drawings under the Fine Arts Copyright Act is that they're really still not thought of as being artistic in a fine art sense. They're artistic in an engraving sense in terms of the method used to make them. But there was a brief period, as I mentioned, until 1911, where you had potentially 3 regimes that could protect maps for their informational qualities as literary works and for their physical and aesthetic qualities as engraved prints, although not as fine arts. So, and this was a case that I discussed at the Tosca conference earlier, a few months ago, where it made a difference which regime you tried to argue to put maps in when an infringement occurred. So this was a case brought by the lithographic printing company Stannard & Son. They hadn't registered their bird's eye maps at Stationers' Hall, which was required under the Literary Copyright Act. So if the case was brought under the Literary Copyright Act, they couldn't succeed. So the defendants were keen for them to fall under the Literary Copyright Act. They had to argue. So in the first case that they brought, they failed. Then the second case that they brought, so against Lee, they failed. And the second case they brought against Harrison, they were much more careful to refer to their works as views and emphasize that they were engravings. So in that second case, the court thought that they were engravings, and so they were able to succeed in their copyright infringement suit.
Thank you. That's really a very interesting binary there. Taking a different slant now, you mentioned Matthew Edney's book on cartography, and in that he encourages us to think about the process of map making. And I wonder if that approach helped to give you insights into the field, and whether it helps us to understand the approach that you're taking, as a legal perspective, being very new to most historians of cartography. And I wondered if that sort of focus on process sort of brings things together a bit.
It really does. I think it's a really helpful way of framing the work that I've been doing, because I have been concerned to show that maps are more than just what they're a map of, or a physical object, or even a commodity. So looking at the processes by which maps are made and circulate across the centuries, we can see them interacting with a range of different and sometimes competing cultural, political, and economic conditions. And the law is very much a part of that story. So copyright is part of those tensions, a place where they're negotiated, if never resolved. So I think in the book, I'm interested in opening up a space to look at how the activities and interests of the state in map making, so military, administrative, economic, and imperial, imbricate with human qualities like curiosity, ambition, professional pride, map makers' motivations, which are economic, but also the desire for career advancement, for recognition, for participation in a scientific community, or in learned dialogue. So I wanted to present the map not just in terms of what's protected by copyright in it, or as an object, but in its wider significance in terms of the skill and labor that produce it, the motivations of the humans that produce it, and the human relationships and the economics that support a map's creation.
Thank you. And as we draw to a close, I wonder if you could tell us some of the more surprising or even entertaining disputes that you've encountered during your work on the book.
I'll just I'll just refer to, I think one of my favorite cases is the last one that I talk about in the book, and it settles before it goes almost on the steps of the courthouse. So it's Laurie and Nunes. It involves the famous Bartholomew family of map makers. I like it because it's kind of weird in a few ways, but it involved a physical map, which is what you can see on the slide. So it was a map made by making a relief model, itself derived from Ordnance Survey data, or an Ordnance Survey map, which was then photographed using the autotype process. So Laurie, who was a schoolmaster, made this map, and he sent a copy to Bartholomew's. They weren't interested in buying it, but they kept it on file. And I think, reading between the lines, they were looking for a map to go in the front of their atlas. Some years later, they found it in their files. They hadn't really noted down anything about it, and they thought, oh, we'll use this. This will make a good frontispiece to the Royal Atlas of Scotland and Wales, which was then published in 1899 by George Nunes. And Laurie was infuriated by this, and he brought an action against them. And it was pretty cut and dried in terms of copying. They had found it. They hadn't thought really where it came from, and they used it. But what I like about the case is that because the Bartholomew archive is such a fantastic resource, and it contains all of the correspondence between John George Bartholomew and his lawyers, as well as the lawyers with each other. And so you get a sense almost in real time how Bartholomew reacts to this case and how deeply the litigation affects him mentally and physically. He was already almost an invalid due to TB, and the case really makes his health go downhill. So I think that's an example of this kind of phenomenological epistemology that I'm interested in exploring, where you kind of uncover from the dust of history a real life interaction with the law. So not just the kind of what lawyers and law students see when the case is decided and you've got a judgment, the outcome of the case, which is fixed. Here you kind of, that final judgment is purged of the emotion and messiness of the human experience with the law, which you really get in this case.
We're sort of back to the process then, the fact that it's very much a human process, and we can forget that, I think, sometimes. So a final, penultimate question really is just to broaden the our discussion away from the sort of strictly legal and strictly cartographic aspects of this to the geographical sense of things. So your top subtitle draws attention to the role of the law on copyright in the circulation of geographical knowledge, and that's something that's of particular interest to geographers. And I wonder if you could just comment on that, how the law acts as a help and a hindrance in this circulation of geographical knowledge.
Yes, so I mean, this was the thing about copyright, is that it helps and it hinders. And in a way, it helps by hindering. That's the point of it, I guess, that a utilitarian would say. The idea behind copyright is that by granting property rights, you encourage people to do something they might not otherwise have done. In this case, create maps which circulate and further geographical knowledge. Because without those rights, they can't make enough money, because competition will drive down prices to cost level or below cost level, because you can copy without and cut out those earlier costs. So property rights create artificial scarcity, which drives up prices and means that people who make those objects can make a profit or attempt to make a profit. But higher prices means less access for people who can't afford to pay those higher prices. And property rights mean less circulation of the knowledge. So it's always about finding a balance between those two. So I guess I believe that in the 18th century, the law probably had a better balance than it might have today, because of cases like the Moore cases that I referred to earlier, where it was held that it was okay to copy maps if you produced a better map. And there was a kind of furthering circulation of geographical knowledge built into the way that the statute was interpreted. The property right was much more limited, so it was limited to identical or inferior copies. Today, the right has expanded in ways that I think hinder, in a lot of ways, the circulation of knowledge, because it's much harder to copy except for much more limited purposes. On the other hand, I also think that the Hydrographic Office, and to a slightly lesser extent, the Ordnance Survey approach in the 19th century, also came down on the side of circulation by not enforcing copyright, by trying to use it to encourage circulation by dividing up markets. And the Ordnance Survey in particular came up with a range of different ways to try and police the boundary between data that was free to be used by others and circulate freely for beneficial purposes, which can be contrasted to, I guess, their much more grabby approach in the present day.
Thank you. Yeah, that's a constant tension that we need to negotiate. So one final question before we open the floor to questions from our audience. I wonder whether this book, writing the book, has spurred you on to further research on maps, and if so, whether you could tell us a little bit about where your inquiries are heading.
Yes, so when I started this project, so I was supported in carrying out this work with a grant from the Australian Research Council. And when I applied for that grant, I said, because it was the Australian Research Council, I would work on British maps and also Australian maps. And then I guess not that long ago, but when the book was kind of nearing completion, I realized that I would probably, I mean, it's quite a long book already, and if I included all the Australian material, it would never be finished, or at least, you know, not in a time frame that the Australian Research Council would be happy with. So I still, but I had still done quite a lot of research on the Australian material. I published one short journal article on it. So I do have quite a lot of work that I would like to do using the Australian material. I wanted to use that because I thought it was important to kind of, because of those imperial aspects of maps, I want to look at it kind of, this book is, I guess, looking at it from the imperial centre, whereas the Australian material allows you to look back from the periphery of empire. We inherited the copyright law from the UK. So how does that play out in different kind of socio economic and cultural circumstances? So there's a project there which I'm looking forward to moving on to. Maybe I'll move into the 20th century. So the book ends with World War I, because I think things change a lot in the 20th century with the different ways that data is created once you get into kind of aerial photography and drones and satellites. So yeah, that might be something interesting to look at as well. Yeah.
Excellent. Well, we'll very much look forward to seeing that in print and wish you every success with that. That was a wonderful conversation. Thank you so much. That was very rich in ideas and examples, and I'm sure it's given me a lot to think about, and I'm sure it's given our audience a lot to think about. So it's a pleasure now to pass over to my co-convener, Nick Milley, who's going to chair the Q&A session. But let me just thank you again before we get to that. Over to you.
Thank you, Liz, and thank you, Isabella. You've certainly got potential for a whole lot more work. I'm very impressed that you're prepared to go deep into the 20th century, and Australia has got an awful lot to look forward to, I think, if you go ahead and produce another book on the situation in Australia. So absolutely fascinating talk. And I have quite a few initial thoughts. So before people start bombarding the Q&A with questions, first of all, I'd just like to ask, what became of Much? Was it £40 you said the fine was, or yeah, Much had to pay, which doesn't sound very much by today's standards. What do you know about whatever happened to him?
Well, I don't really, he doesn't learn his lesson, I don't think. I think he goes on making piracy some of cyclist maps. So I think he gets in trouble, as I recall, with them again. But yeah, I don't really, because I didn't really go beyond, I think that happened in 1913 and I stopped in 1914. But I think just from looking ahead at some of the Ordnance Survey materials that he doesn't go away as such. Yeah.
Okay, thanks very much. Another thing, I'm sticking with the 20th century here, unfortunately, but one thing that struck me was the change in attitude, certainly with Ordnance Survey, in that the start of the century, there appears to be, as you've said, this intention from Ordnance Survey to share and promote cartographic data. And by the end of the century, they're a very different beast when it comes to copyright control. What was the trigger, do you think, to go from that early situation to what later transpired?
There's no one trigger really. It's a kind of a very slow and complex process, and they, because they're always aware of the copyright issues, but they do go for a long time without worrying about, you know, asserting their rights at all. So I think what really changes is they become, I guess, more and more professional over time. They've got more, you know, by the end of the century, they've kind of mapped that, you know, they've mapped it all once at least. So they're kind of moving into the updating stage. And I guess the private trade has changed a lot too. So by the end of the century, in the early years of the 20th century, they have probably their main competitor is Bartholomew's, which just has a much better handle on the market in a lot of ways than they do. So they become increasingly concerned about how the map sellers are marketing their maps using Ordnance Survey in the title. So it kind of in a lot of ways shifts from being a concern over they're happy for them to use the data, but they don't want them to have it in the title, because there's that, then it makes them a much more direct competitor. Of course, the private map trade wants to use it in the title because that shows how accurate their maps are, because they've got the latest Ordnance Survey data. And they say nobody is fooled in a way because they know it's a Bartholomew's map and not an Ordnance Survey map. So it's much more about that kind of about controlling their reputation really than about how their data is used. But it's really hard to separate those two things. So, but they kind of just get more and more concerned about their reputation rather than the data. And I wonder if the Crown copyright thing just seems like a good opportunity for them, because there's legislative, Britain enters an international convention that means that they have to change the copyright law. So they need to have a new statute in 1911. And the Ordnance Survey kind of sees this, let's just settle out this Crown copyright thing, because one of the concerns that they had all along is who owns these maps, who's put their name on the maps. Some over the years, sometimes they put all of the surveyors and the hydrographer on the map. Sometimes they just put the hydrographer. Sometimes they just say UKHO. They haven't really been consistent in how they assert their copyright claim. And they're just not 100% sure that they've got if they wanted to assert it, if there might be some problem with saying who is actually the author and the owner of this work. Because, of course, also by the end of the century, they've been updated a lot of times. So it would be really hard to say who was the author. And even if copyright has expired, when does the copyright start, and who is the author? So they think that Crown copyright will solve this as well and put them into a stronger position to bring proceedings. And then they do kind of periodically over the course of the 20th century bring actions right up until a few years ago, I guess, but more with their databases.
Okay, thanks ever so much. That really does give us a flavour as to how things have evolved through different legislation. We have a question from the audience. So how much do you think changing technology affects people's attitudes to copyright? With an early printed map, ownership of the copper plate meant ownership of the map. In contrast, modern technology makes copying so easy that people have become more relaxed about copying. Do you think this has been an ongoing process with technological advance leading directly to changing attitudes?
Almost certainly. Probably some people in the audience remember the Home Taping is Killing Music campaign. You kind of, this is, I guess, been a persistent theme in copyright when new technologies make it easier to copy. In the early days, you had to have the plate, so copying was harder, and technology has made it easier and easier over the years, and it's led to, I guess, various, I don't know if you would call them moral panics, but certainly concerns, which we see today, I think, with ChatGPT and artificial intelligence. So I think the interesting thing is the copyright, the technology changes, but often the concerns, you see the same thing happening over and over again. But as copying does get easier, people's attitudes towards it do change. I think you see that across all of what they call the copyright industry. So artists are concerned that their images are not being respected anymore. Authors are concerned.
Okay, thanks. I certainly wasn't expecting to hear ChatGPT mentioned this evening, so that was an interesting one. But in general, we've looked over quite a long time frame, a long period of time here. What was the situation in other countries? Have you been able to analyse what was going on elsewhere in the world, any other particular countries? Were map makers, cartographers having similar legal battles to the situation in Britain?
It took me 12 years to write this book. So I have not really had time to look at other countries, although I would love to. Yes, in Australia, yes, similar kinds of things. So I would imagine that there would be, in the US, I'm aware of some early US litigation as well, which is interesting, but those are the only countries that I'm aware of. Unfortunately, I haven't had time to look into too many different jurisdictions.
It's okay. Plenty of future research, perhaps. I'm sure you've got plenty of other things to do. So,
any partners out there?
They may well be out
languages than I have.
But you spoke about the process of copying becoming morally dubious. When does that change happen? Was it for commercial reasons, or was it moral outrage as a cover for commercial needs?
There's probably people in the audience who know more about this than I do in the early stages, but I do get a sense that from very early times, map makers who've put a lot of effort into making a map and see it copied are personally affronted by this. And there's an economic aspect to it, but probably also, I don't know if it's a kind of just a universal human thing, is when you've worked really hard at something and someone copies it, it upsets you. But it probably in the earlier periods, it would be just much more a direct copy or copying it as yours, like, so I'm selling someone else's maps, whereas the kind of the using of data and updating was much more acceptable. But again, that might a bit depend on the nature of the person involved and their kind of their market and the effort that they put in the first place. So I think you see senses of it early on, but it's much less universal than it later becomes, especially post-copyright.
Sure. It's interesting that you were talking about the way people are thinking, and what struck me towards the end of your talk was when you were talking about using the Bartholomew archive, and it seems like you almost had this deluxe opportunity of research in that you were seeing how Bartholomew himself was thinking and the impact on his health, etc., etc. is the Bartholomew Archive unique in terms of the research that you've done on copyright legislation, in terms of getting to grips with the characteristics and the feelings of the individuals involved?
Well, I hope so, because if it's not, then I've missed something that would have been really useful in my book. But I think that one of the frustrating things is, early map makers there's just not that many archives out there of their personal archives available. So I did visit the archive of Imre's and the Ordnance Survey and the Hydrographic Office, but there's fewer kind of archives left for map sellers than there are for, say, booksellers and book publishers. So that's frustrating, because as a historian, I'm interested in the people and the kind of and the other thing about the legal archive is that it leaves traces that you wouldn't find elsewhere. So if you look, you find the human stories in the records that the litigation leaves behind, which is what makes it such a fantastic resource. But you still have to read between the lines, and so some archives are better. So Chancery is better, the Court of Chancery, because you have these enormous writs, and they have to tell the story in not writs, pleadings rather. And to get your injunction, you have to set out the story. And sometimes, although there's to a large extent they're formulaic, you can sometimes read into the language, like people being a little bit miffed about things. In the common law, so the King's Bench and the common pleas, they're much more formulaic, so you don't get the human stories so much, you just get what happened. And an affidavit was read, not what was in it, but in the affidavits you find really interesting information out about people and how they react to things. So that's why the legal record was good as well.
Okay, thank you. That's very much looking at the people directly involved in the cases. Is there any public resistance to the restriction of copying? So a suggestion that cartographers are perhaps being greedy or selfish?
Yeah, so from time to time there are newspaper stories about this, particularly over the Ordnance Survey. Everyone gets worked up about the Ordnance Survey. But yeah, there's a number of disputes make it into the papers, and then you have people writing in and commenting on it. So one of the cases that I talk about that relates to road books, a Scottish road book case between about copying the Scottish Book of Roads, got into the papers, and there was a lot of back and forth. This is ridiculous. No one should be able to claim rights in the roads, or don't be so naive. It's really hard work, and people need to make money. So yeah, there's a handful of times where it does kind of spill over into the news, which is interesting, and see people writing in.
Okay, and do you feel that let's say early geographical societies take a dismissive view about map copyright at all, or given their remit to encourage spread of geographical knowledge, are they more relaxed about it?
So I didn't get to look into that in too much detail. I went to the Royal Geographic Society and had a look there. I wasn't able to spend a huge amount of time there, and if anyone knows the records better than I do, I would love to hear if they found something else. But I didn't, from what I looked at, it just didn't seem to be something that they were interested in, because, as you say, they're much more interested in kind of getting the information out there, or setting off on explorations and kind of the funding of it, but not through copyright. So
if that's the view, let's say we're looking at the societies, do you have any sense about the general map buying public? Do they have any views on the authority that copyright brings? Perhaps where witnesses might have said they want to know that they can trust maps. You mentioned earlier some of the cases with the navigational charts where witnesses were brought in to say these are the finest charts. So do you think the general public sees a role for copyright in that?
I guess the witnesses, it's really hard to see the general public. I would say that the general public then and now really doesn't understand copyright law and would prefer not to think about it unless they really have to. So yeah, you just don't get the voices of the general public. The witnesses are always kind of experts in some sense or other. So people who would have views about maps or engravers, about the process. And they're usually on one side or the other. So they kind of have an incentive to say this is ridiculous, copyright shouldn't subsist in this or not. There's a couple of kind of inquiries later on into Ordnance Survey maps, where you hear more voices about what the kind of work that maps should be doing and how or if the information should be made available or whether copyright is an issue. But again, they're not members of the general public. Sometimes they're kind of, I guess, in one of the later kind of public inquiries, you get people from cyclists organizations and motoring organizations who have views about maps and to what extent they should be accessible. So maybe a little bit later on in the period. Yeah.
Okay. I'm keen to explore more from the professional legal side of things. And there was a case where you were describing what the map is. Is it an engraving? Is it a view? And the choice of language used by the people in court had an influence in the direction of the case. So what do we know about the legal teams working on this and their use of language?
Really nothing except what you read in the record. So yeah, again, you just you don't really have access to any preparatory documents, so unless it was kind of on the record, except for in the I guess in the Bartholomew archive, which is an exception. But I don't see them kind of workshopping their language so much. So it's really you kind of just have to read the text and draw conclusions from that. I mean, you do get some of what they argued in court, sometimes in a summary form. There's a question of, in the early periods, how reliable those summaries are. Yeah, there's no kind of direct evidence of what they're thinking. You have to kind of draw the inferences from how it plays out, assuming, I guess, an assumption that I tend to make from the work of Toby Milsom, who's a legal kind of prominent legal historian, that lawyers are mostly interested in getting their clients out of trouble. So they'll make the expedient argument, and sometimes then you can see how that kind of argument has led to a change in the law. But Milsom argues it's a mistake to kind of see a lawyer going in and saying, having the bigger picture. By and large, they're like, what will get my client out of trouble today? So how can I make that argument?
Thank you very much. Well, I want to bring this evening to a close now. You've done plenty of talking, Isabella, but we've got one final question for you, which I think needs to be asked. Are you alone amongst historians of law in having an interest in maps?
Yeah, I think so. I haven't met anyone else doing this work. But I think, yeah, I mean, no, so there's a few legal historians who are interested in maps from a kind of territory and sovereignty point of view. So there's an interest in map history there. But I think there should be a lot more interest in it. I think there's a lot of things that you could do aside from copyright. I really wish a property lawyer would look into the Ordnance Survey. I think that would be a really interesting project. for someone else, maybe me, in 20 years' time.
Fantastic. Well, I hope you've inspired plenty of people in the audience tonight. That's been a real eye-opener. And hopefully plenty of the people here tonight will show up in London next week for your Maps and Society talk, which I'm sure will be absolutely brilliant. And for those who can't make it, there's always the Cambridge talk next year. So you're
Hopefully
seriously
people don't get sick of me, but they are going to all be different talks.
well, they're all going to be as brilliant as that. I'm sure it's going to be absolutely marvelous. So thank you, Isabella. I'd like to thank our technical team in the background, Stuart, who you can't see, but thank you, Stuart, for pulling this together. Thanks to Liz for asking all the questions, and thanks to the audience for chipping in with their questions too. I hope everybody has a good evening if you're in Britain. If you're elsewhere, a good afternoon, perhaps. And just to remind you, we mentioned at the start, there is the Tosca field trip for those who are in or around the Oxford area, which is taking place on the 30th of this month. So what, in 3 weeks' time? It's the Tolkien Maps event. If you want to come along, let me know, and we will endeavour to book you in. Places are limited, but I think we've got 7 spaces left. So Isabella, thank you very much. Liz, I don't know if there's anything else you'd like to add at this stage, but thanks everyone for helping make a very interesting evening as far as we were concerned. Isabella, that was great. Thank you.
Thanks, Isabella.